That's great. Well, nice to see everybody. Our first meeting of the new year, and one of the things I thought it might be useful to. Uh, Hello, Thomas.
Hi, Thomas.
Uh, One of the things I thought it might be useful to consider on the front end are topics or issues or presentations that any of you might be interested in this group doing. We have a fair amount of, I think, flexibility to push out all kinds of content and to do all kinds of meetings. I mean, I think. Well, Hannah, why don't you review the options again, just so everybody knows them, just the different avenues that are available to us.
Sure. So we have, obviously, of course, these meetings, which we could also do as webinars and invite an external audience, do PowerPoint presentation, that sort of thing. So webinars are always an option. I will say with the webinars, we have seen a slight decline in attendance with those, whether it be from people being zoomed out or what the case is. If we do go that route, we definitely want to make sure it's something that is very timely and relevant and captivating for an audience. We haven't done the podcast yet, Jonathan, but we've been talking about it in a number of groups. But, sort of similar how we would plan to do the podcast were just audio recordings that we'll then go back and edit, that we would do the same way. So as if we were in a podcast room together, recording the Zoom meeting. Those, of course, would be some shorter audio clips, probably no more than 15 minutes. So that's an option. I know we've talked about that for a little while, Jonathan. And then in terms of written content, we've had a number of groups, and I think we've talked about it in this group as well, that have done published guides that are, they're electronic, so we don't actually do printed publications, but we do those on a country by country basis. We post the entire guide on our website in JD Supra, and then the individual countries as well. And then, of course, we authorize our firms to post those on their websites as well. And then the last couple of options would be articles, or if we wanted to do some sort of blog, that of course would mean we'd have that content on a very regular basis, like a weekly basis, if we wanted to do something like that. But articles, of course, are always, whenever you want to write an article with another member firm and put the WLG logo on it, we can easily do that. And of course, again, we would push that out on our website, social media, and JD Supra. And for those of you who might not be familiar with JD Supra, there's a number of companies that do what JD Supra does. Lexology, I'm trying to think what some of the other ones might be outside of the Americas, but they're basically a content syndicator that takes our content and pushes it out to appropriate audiences, whether it's in-house counsel or editors of other publications that then pick it up, news outlets, that sort of thing. And we've seen really good pickup with our publications that we have posted on JD Supra. I think that's it. Did I miss anything that we talked about, Jonathan? I think those are all of the options.
No, I think that's good. The thing I hadn't really thought about before is the blog. And what I like about that is it's so easy, and it just kind of pushes our group out on a very frequent basis, and any group member can contribute. What groups are doing a blog at this point?
We don't have any groups at the moment that are doing blogs. We've talked about it, and I think the one challenge that we've had is we need content on a regular basis, which, for blogs to really work the way that blogs are intended, it would have to be set like a weekly basis that we would be pushing content out. That being said, we could try some sort of hybrid model of a blog where we set up a landing page and then, transfer that data to an official blog. I'm happy to consider. It's a matter of getting the content from our members.
Yeah. I like that idea. I mean, I just think I think things are happening so quickly in the market and in our respective jurisdictions. And, as we all know, an article takes a bit more time, podcast takes a bit more time, but
Mhm.
I like the idea of the blog. Uh,
And I think Jonathan, with the blog, the thing to remember, something like that is it doesn't a lot of times we get into these articles and the footnotes and the legal jargon and all of that, whereas the blog is more for an audience that, you have to put it pretty plain, basic black and white terminology for any reader to understand, and it's generally shorter, like something that you could sit down, write quickly, do a proof of, so that you are right that the blog content should in theory be easier for us to write and should be shorter.
yeah, well, perhaps, I mean, I'd like to do this in a way where all of us can offer content, but maybe Chris, you and I and Satwinder can get with Alexandra and we can think about how to maybe trade off some initial posts. And I take your point, Hannah. I mean, I think blogs are really at the level of, let me tell you why non-debtor releases are a bad idea and why courts are starting to really get angry
Mhm.
about them. I mean, things of that nature. Um, well, I think from my perspective, my hopes for this year are, in addition to our, our regular meetings, I'd like to see if we can, generate a podcast or two, or a webinar or two. I mean, I think the podcasts, may offer a little bit more flexibility in these over Zoom times. And then, I think maybe we do explore this blog, but let me just throw it open to the group, and Chris, you and Satwinder initially, what are your thoughts on, content and connection points we might try to make in the coming year?
I agree with the zoomed out notion. I think webinars have become an increasingly less popular option as this thing is dragged on. And people are excited to actually get back to meeting in person. So I think that would be at the end of my list. John, you and I talked about doing that podcast for a while, so I think that's a great idea if we can get it off the ground. And yeah, some sort of blog. I mean, we produce, periodic content updates. So if it was a question of, once every month or two, we had to produce some Canadian content as well. I don't think there'd be an issues with just kind of taking what we already have on the shelf and putting the WG logo on and put it on a blog. So I think that's a good idea.
Satwinder?
No, I think, Jonathan, I echo what Chris is also saying. But as I was just putting it up, is that how best we can just take it jurisdiction wise and other things, maybe in association with certain other organizations or chambers. The webinars would be a good option which we can take it. Particularly from India's perspective, which I'm just looking at it, is now the personal insolvency of the of the guarantors to the corporate debtors. That has also been, notified. Now the personal insolvency as such has not yet been notified to that extent. But larger issue is coming up is the cross-border insolvency, where you see the realization of assets and other things, where the governments are taking, how the cross-border insolvency will take place, how the UN settle laws would be applicable, and how the invocation can be done. I think these are the topics which are the topic of relevance for every jurisdiction. So maybe that we can identify the topics and then identify that by when we can organize the webinars looking at the jurisdictional issues in each of the countries on the realization of assets of the either the personal guarantors or of the corporate debtors, or the prepacks where the resolution could be there, and what could be even the tax impacts which are coming. So maybe that, I think it would be where we can identify different topics,
Okay,
set
well,
it up,
thank
and then take it forward for that. But yes, I think the webinars would be a good option rather than having a physical meetings. Uh, Even the regional meetings also, we can handle it well as the through the webinars or through online. I think that is creating more impact where you can ask others, you can involve others, and that will give my
Yeah.
experience. My experience overall is now, but that recently we had a session from the Institute of Company Secretaries where I am one of the members, and so they organized with the adjudicating authorities. They called the judges, the members, and had the webinar, which was attended over by almost 2,000 people, where it was a good interaction. So maybe that we can involve the regulators of the local, and they can easily come in and pitch in for that. So maybe at an international level also we can organize the programs, and that will also give a good branding to the WLG, because under the aegis of WLG and all, so it will give a good branding overall of the WLG vis-a-vis the other different regulators in different jurisdictions.
Yeah, that all sounds very good, Satwinder, and I think we can follow up on all of that. Hannah, do you have a sense of sort of mechanically, if we generate some of the blog content, where we would put it? Like, in other words, would it be a JD Supra platform? Would it live on our website? How would it work?
I think it would live on our website. I haven't talked to Tori. Tori does all of our technology for us. And I have not talked to her recently about that. We had discussed WordPress at one point in time, but I think what we concluded was that we would do something on the website. It would live there. If we decided later in time it was too much, we didn't like how it was on the website, we could transfer it over to a WordPress. But yes, we would still push this out to JD Supra. We can push any of our original content out that comes from World Law Group. We cannot push individual member firm content out, but we can push out anything that we create via JD Supra. And then, of course, we always share it on our social media channels.
Okay, maybe what we can do, and anybody on the call is most welcome to join me in this, but maybe we could have a call with Tori and just figure out mechanically how to get it launched. Because what I would like, and what I think would be very dynamic, would be one of us posts, we do some kind of push notification to the group when we post, or maybe even a push, maybe it just, there's a hyperlink that pops up on the main site. And then we have just some ability for other group members to not only make their posts, but to respond. So, I might say, Christian, I'm astonished as to your view on this director liability issue. Doesn't work at all that way here. Just have it be a bit conversational, but maybe perhaps we can talk about those mechanics. So before we shift gears, any other thoughts from anybody on the call as to other kinds of content you'd like us to pursue, or other vehicles for for building out our profile? Okay, well, by all means, please definitely share your thoughts as you have them on this subject, and I think we'll be in touch as we advance a couple of these initiatives. I thought what we might do with the rest of our time is give you a couple of presentations. Chris is kind enough to have worked up a little update on reverse vesting transactions in Canada, and he can report on that. I had spoken at a prior meeting about some hot topics in the US, one of them being non-debtor releases. And there have been some fairly dramatic developments on that front in the US, and I can do a short report on that. And then we may just, before we drop off, go around the horn and hear from each of you what's going on in your respective jurisdictions. So if that sounds okay to everybody, Chris, maybe maybe you could give your report on that issue.
Sure, John. So reverse vesting transactions is what I'm going to talk about. I'll kind of circle back to explain what those are to you, but just to give you a bit of background, there's two basic restructuring options in Canada under our company's Creditors Arrangement Act, or CCAA, which is similar, at least in practice, if not substance, to Chapter 11 in the US. And those two principal restructuring options are a plan of reorganization or arrangement and a sale process, concluded with an asset sale that would see the assets vested out free and clear, similar to a Section 363 sale under the US Bankruptcy Code. And one of the reasons, there actually is some statistical analysis, and I think it was somewhere around 60 to 70% of cases in Canada end with an asset sale structure versus a CCAA plan. And I think one of the principal reasons that is that you don't have to go through a creditor vote plan process. And that can improve the speed in which you can get a deal done, and also just avoid the inherent risk and uncertainty of a creditor vote in some cases. And for those that are familiar with an asset sale in the context of a restructuring transaction, and I think most of the jurisdictions on this call have a similar concept, but basically the assets are conveyed out of the debtor estate to a purchaser free and clear of any claims, and the cash or whatever purchase considerations being provided by the purchaser goes into the debtor estate and is distributed out, in accordance with, sometimes you do a plan, sometimes you just do a bankruptcy distribution order. There's a bunch of ways to get money out to creditors after you've done your sale. There's three potential drawbacks to an asset sale. One is conveyancing issues. You have everything from potentially transfer taxes on real property or just sale of a business. You have to go out and get consent to assignment to contracts. If you have an asset or a business with a lot of registered assets, like vehicles, real property, you have to go through all the conveyancing and transfer steps there, and that can just be a bit of a grind, can add some cost to the process, take some additional time. A second big issue that comes up is permits and regulatory licenses. Those are obviously specific to a legal entity, and if you operate in a highly regulated business like telecom, like our cannabis market, for instance, those are critical to the functioning of the business as well as the value of the business. And if you do an asset deal, your purchaser needs to go and have that license typically reapply for it. In a lot of cases, there's not an easy way, if a way at all, to transfer a government regulatory license to a purchaser. So, that's another drawback of an asset deal structure. And third, and frankly, this might be the most important from a value perspective, is given the type of companies that you're dealing with when they're in insolvency protection, they typically have a lot of tax losses and other valuable tax attributes. And when you do an asset-based deal, those tax attributes are left in the debtor estate, and are kind of lost. We have various laws under our tax regime that kind of prevent, in many cases, the monetization of those tax attributes and assets. So you kind of lose that value, and the purchaser entity, which is, in most cases, as you know, is just operating the same business, albeit delevered with the group of assets they've acquired, and it doesn't have the benefit of that go forward tax base. And the obvious, I think probably all of us are also, to a degree, just kind of corporate law M&A practitioners, and the obvious fix to all of these in any other scenario is to just do a share deal, right? Because if you do a share deal, everything just sticks in the entity. And so the way you would typically do that in Canada is you pursue a plan of arrangement or reorganization. But as I said off the top, there are some drawbacks to that as well in terms of timing, uncertainty, and just the cost and risk of going through a plan process. And so a few years ago, and it was actually our firm, we kind of had it's a bit of a funny case in the sense that it wasn't a big case. It wasn't really a viable business, but it had an environmental license. It had a lot of tax attributes. And we developed what we call a reverse vesting transaction. And the name is very apt. As the name suggests, it's really just the reverse of your usual free and clear asset sale. Instead of transferring the assets out free to clear, what we developed was a process where you transfer the excluded liabilities of the debtor into a newly formed shell corporation that we affectionately call Trash Co, or sometimes a worse name that you can probably guess. And the result is you end up, just like in a plan process, you end up with a delevered debtor that's free of the liabilities that led to its insolvency. And of course, that addresses the three main issues with an asset deal I described above. You don't have to worry about conveyancing issues. You don't have to worry about regulatory permits or license transfers because you're just dealing with the same corporate entity. And I'll tell you, just as a quick aside, like this has been a huge development in the context of restructuring our cannabis industry. That was a big thing in Canada over the last 5 years, where we had a ton of cannabis companies IPO. We're a few years, probably not ahead of our European friends on this, but ahead of our American friends. And so we had huge interest in that industry, I think, trying to get ahead of the curve so they could make an entrance into the US market when it became available. And there's been, typical, the money flooded in, huge stock valuations, and then they decided or realized that there just wasn't as much of a market for cannabis in Canada as everyone thought. And I think the US process has been a little slower than people hoped. And so you've seen, massive downturn in that industry over the last couple of years, last year in particular, and a lot of restructuring. And obviously, given the nature of the asset cannabis, heavily regulated, very difficult licenses to get, crazy, security clearances that are not easy to transfer. You can't transfer them. You have to make a fresh application. And so being able to preserve the debtor entity in the context of restructuring a cannabis company is critical. Otherwise, you probably can't get a deal done. And then thirdly, the loss of tax attributes. I mean, I can tell you we did a deal last year where we preserved $178 million of tax losses. That will be dollar for dollar set off against future tax or future profits of that company, which that was a company very much just beset by the COVID downturn, a good company otherwise, but just crushed by COVID given the nature of its business. And instead of doing an asset deal where the purchaser would have taken the business with no cost base, it basically just preserved the entire cost base of the company, subject to some set-offs for debt forgiveness and the like, but a much better economic circumstance going forward for the company as a result of having those tax losses. And the result, I mean, and this is, I think, where the thinking is going, is people kind of take a step back and they say, this is a great mechanic, it gets you really to the same end result as you would through a CCAA plan of arrangement or something similar to a Chapter 11 plan, but without the timing, the time that it takes to go through the plan process, without the risk of a creditor vote. Some issues, you can expect there's been a lot of scrutiny around this type of transaction. Just to give you a high level without getting too down into the weeds of some of the points that are less relevant as you think about these issues. One is the jurisdictional basis for it. We do have, similar to Section 363, we have Section 36 of the CCAA, which is a codified regime for asset sales. So there's a statutory basis for the vesting out of assets of a debtor free and clear. There is less of a statutory basis, let's say, for a first vesting transaction. Some people have tried to argue that it does fit within the framework of Section 36. Between those on this call, I think that is a bit of a doubtful, dubious argument. However, we have a fallback. We have a provision under the CCAA, which, I always joke, if you don't know what statutory reference to make, just say Section 11, because Section 11 says the court can make any order that it considers appropriate in the circumstances. And that is a really, really valuable tool. It comes up in the context of third-party releases and non-debtor releases that John will talk about in the U.S. context. But basically, anytime you need to find a source of authority, that is a provision you can point to. And courts so far, at least lower levels in Canada, have found that there is statutory jurisdiction for reverse vesting transactions. It has been considered at the Court of Appeal, two provincial courts of appeal, not twice, I believe, without kind of going in specifically to the jurisdictional issue. They have not overturned reverse vesting transactions that were contested, has not gone up to the Supreme Court yet. But I'd say, at least from a jurisdictional basis, it seems that we're on pretty solid footing. The second issue that's come up, unsurprisingly, as I talked about, is if this is seen as kind of a way or a means of sidestepping a plan and creditor democracy and voting on a plan. That's another theme that's emerged. There was a case out in British Columbia the past year where a debtor proposed a plan. It was opposed by one of its significant creditors who in fact had a plan veto, and the debtor pivoted to a reverse vesting transaction, which of course led to the creditor just objecting and saying they've, are basically just trying to do indirectly what they cannot do directly. And ultimately, the court approved the reverse vesting transaction, I think, on the very specific facts of this case. And there's an argument to be made that the court got that one wrong. It was a university, a private university in British Columbia that they were trying to save. So I think that probably played into the court's decision a bit. But that's been another focus is, can you do these transactions when you're really just doing them to prevent your creditors from having a vote, including your creditors who might have a plan veto vote. And so last week we actually did a case, kind of a mid-market mining case where we did a reverse vesting transaction, and mining, again, heavily regulated industry, lots of mining permits, lots of mining claims, hundreds of them. You would have had to go through that process, as well as some valuable tax losses in the business. And we structured it as a reverse vesting transaction from the get-go. Our judge was, very interested, and he approved it and found that it was a case that was appropriately, concluded through a reverse vesting transaction. But he started to put a bit of a framework that I think practitioners will have to apply. And I think the three takeaways from that case is, one, we should regard these reverse vesting transactions as kind of the exception to the rule as opposed to the norm. And furtherance of that, you do need to show good cause of why you're doing a reverse vesting transaction versus a usual asset sale transaction. And so that would be something like, in the context of a cannabis case, we have this very valuable license that, a purchaser would not be able to get, or not be able to get on a timely basis, and the business would fail in the interim. And two, you need to demonstrate that no stakeholder, and I think this ties in, arguably to that case in British Columbia I mentioned, no stakeholder is worse off relative to other viable alternatives. Or maybe put more simply, is anyone's ox being particularly gored by going down the reverse vesting route as opposed to a planned route or a typical asset sale? So it's a novel means of completing a case, very popular with practitioners and with clients, because I think it's just very quick and efficient, good execution certainty. And we'll see where it goes. I think the judiciary is starting to get a little concerned that it's just becoming, everyone's going to do a reverse vesting transaction because why not? And we'll see where it goes in the next couple of years. And I think the reason it may be interesting for you all is I don't know. John, you'll tell me. I can't see that you'd necessarily be able to do something like this under Chapter 11, but I know some of the other restructuring regimes have language similar to Section 11 of the CCAA in terms of the court being able to authorize something, if it considers it appropriate, and you may have some license to develop a similar type of transaction in your regime or in your jurisdictions. So maybe I'll pause there and just see if there's any questions.
Chris, that's excellent. Thank you. Let me just first of all ask a question that Trolls put in the chat. And he asks, how do you conduct the transfer of the debt and not have any tax implications in Canada?
So it's interesting. So there's a couple tax issues to think about. One is there is debt forgiveness in the debtor entity, assuming there is liabilities being excluded out. So that is an issue you have to deal with. In terms of the actual transfer of the debt, what we've done, and this is, I think this is more protective structuring than anything else. What we've done to ensure that there's no gain in the debtor entity is we actually transfer I gave you a bit of a short-circuited description. Typically what you do is you transfer out both the excluded assets of a deal as well as the excluded liabilities. So basically the assets that the go-forward company doesn't want, which are typically very few, as well as the liabilities the go-forward company doesn't want, which are obviously a lot. And the concern I think the tax practitioners had is that if you transfer both those excluded assets and excluded liabilities, the CRA, which is our equivalent of the IRS, our taxing authority, could take the view that in effect the value of those liabilities, even though they're worthless because there's no value to pay for them, but just the face value of those liabilities could be taken to cause a gain on the sale of those excluded assets, which would be attributed back to the debtor entity. And what we typically do now is we actually create two trash codes, and we transfer the excluded assets out to one of the trash codes and the excluded liabilities out to the other trash co. And in that circumstance, the tax people tell me that there's no concern that there'll be a gain attributable back to the debtor. So that's the one major, tax issue that I've seen on these deals. And the other is just the, forgiveness of debt, that tax implications that arise. And that is what it is. But typically, as I talked about, a lot of these entities obviously have lots and lots of tax attributes. And there's ways, I can tell you on the one deal we did last year, our tax structuring steps were 47 pages to implement the transaction. I can also tell you that I looked at the first draft and then, just kind of gave carte blanche to my tax partners to take it from there, because it's the type of thing that unless you're a tax lawyer, it's tough to stay on top of. But there is a lot of tax structuring for sure going on in connection with these deals also.
Chris, is there any requirement of corresponding amount of assets traveling with the liabilities, or any condition that you have to make Trashco solvent and adequately capitalize it to cover its transferred liabilities?
Yeah, and so that the short answer is no, but it's a concern. And typically what we've seen is the trash codes are incorporated sometimes without directors as free-floating corporations. So they're just basically created, but never kind of truly formed with directors, because people are concerned about director liability. To your point, Sean, about, I'm creating this entity that's very purposefully, grossly insolvent. And I think the answer is, look, you're doing this through a court supervised process. It's all being blessed by a court. And there's no one's hiding the fact of what you're trying to do. It is purely a technical means of getting massive liabilities out of the debtor entity. But that's the type of protections we take, is we make sure there's no directors on that entity when it takes on the liabilities. It's all approved by the court. There's one other point you made me think of. What was it? It'll come back to me, but there was one other point I wanted to make, but for certainly a live issue, but I think one that no one is particularly concerned about, given the whole nature of this transaction is intended to accomplish that. And there's no particular statutory prohibition that I think anyone will be able to point to say, you're offside. Here's the point I was going to make. A lot of these reverse vesting transactions are done in a circumstance of a credit bid, right? So you have a 1L, 2L credit bid. The sale process you've run has demonstrated there's no value beyond the secured debt. And the result is, effectively you're transferring those liabilities out to the residual co or trash co, and there's no value there. It's then an assetless bankruptcy. Unsecured creditors recover nothing. In a circumstance, and I'm trying to think, there's been a few cases where there has been value for unsecured creditors. And what you do in that case is you structure notes between the debtor entity and the residual co's, where the value that's available for unsecured creditors effectively flows through those notes into the residual co, and it becomes your debtor in the wind down CCAA process that makes distributions to unsecured creditors. And then the last piece you do is you amalgamate the two residual co's that I talked about into just an amalgamated residual co that effectively pushes whatever the residual assets are that are available to unsecured creditors and the liabilities back together. And that's your debtor that pursues a plan, for instance, or is just bankrupted, and distributions are made that way.
Yeah. Well, Chris, I think we have our podcast topic, because you're right. The bankruptcy code really doesn't have this in the United States, but we have something perhaps more nefarious we have a maneuver called the Texas two-step, which is, have you read about this?
I have read about the Texas
Yeah.
two-step.
It's called a divisive merger. And step one is, I mean, we've seen it under Texas law, but you split the company into good co and bad co. You kind of section off assets and liabilities. You basically section off the long-term liabilities that are causing you trouble, and then you capitalize with a corresponding amount of assets. And of course, where and how you value the liabilities is the heart of the matter. But you then, in step two, take Trash Co. into bankruptcy. And we've got a really fascinating case study playing out right now in first in North Carolina and then in New Jersey. And that's Johnson & Johnson with its talc liabilities. And they implemented a Texas two-step. And just as Purdue Pharma was sort of the absolute most outrageous facts for non-debtor releases, Johnson & Johnson is the absolute worst facts for a Texas two-step, because it's literally one of the richest companies in the world. It has sufficient assets and financial strength to pay the liabilities 5 times over. And it's potentially going to leave these claimants at the end of trial with a short payout. So it's being tested because it got forced from North Carolina to New Jersey. And there now is a motion to dismiss as a bad faith filing and to attack the transaction. So it won't be circuit court level or Supreme Court level, but we're going to get, I think, the first really significant decision on Texas two-step. And I think it'll be an interesting point of comparison. So would love to talk to you about that. And thanks very much for that update. Super interesting. And I was not aware that it had become such a well-developed tool in Canada, but I'm sure controversy will follow as it has here. If I could, let me then give everybody an update on the non-debtor release issue as it's played out in the Purdue Pharma case. And you all may recall this was one of 3 issues we talked about, I think either last meeting or 2 meetings ago, in terms of emerging US issues that were really reverberating beyond the courtroom and perhaps going to lead to legislative action or greater public debate. And the non-debtor release issue was really top of the list. And just to refresh everybody's memory, what we mean when we say that in the US or Canada, this is when you do a Chapter 11 plan or a plan of arrangement in Canada under the CCAA. And you, in addition to discharging the debtor and its officers and directors, you discharge and release a large group of not only affiliated parties, but also other parties to the economic agreement that supports the plan. So that might be lender entities, that might be private equity sponsors, major shareholders, even major contract parties who have achieved a global settlement to try to further the plan. And of course, over the years, there's been a lot of challenge to those provisions because they not only bind claims that the debtor might hold, claims that are in the bankruptcy estate, but they also bind creditor claims that I'm sorry, just give me 1 second. That they also purport to release creditor claims that belong to parties that are not debtors and are not subject to the bankruptcy estate. So there's been a lot of factual challenges. You're not giving enough money to get these releases. There have been jurisdictional challenges. We're not really before the court. How dare you release our claims? And then over the years, there have been various statutory challenges along the lines of what Chris was saying. This is a remedy that just doesn't exist in the bankruptcy code. And Chris, like your section 11, I think you said it was, we have section 105. It's the same thing. It doesn't say we can't do it. So that's good enough. And Purdue Pharma was setting up to be a really fairly compelling test of the proposition because it was an extremely unsympathetic group of released parties. This is the Sackler family that I think it's probably fair to say bears substantial responsibility for the opioid epidemic in our country and beyond. This is the family that created the product and then really pushed the marketing. So they were enormous litigation targets. They had a fortune estimated at about, 16 to 18 billion US, and they offshored 12 of it. They just made massive transfers to offshore trusts. And then, when the Purdue Pharma bankruptcy was filed, the Sacklers negotiated with the company for a non-debtor release. And the price arrived at was, I want to say, somewhere around $4 to $4.5 billion. So substantial, and certainly enough money to fund a lot of compensation and remediation, but nowhere near the face value of these liabilities. And when it came time to push the Chapter 11 plan through, you had a lot of states and governmental bodies and private plaintiffs groups that signed on because they wanted their share of the $4.5 billion. But as is often the case in these mass tort scenarios, you had dissenters. And this was fought out at great length in the bankruptcy court. The dissenters lost, the plan got approved. And then in the US, our intermediate level of appeal, or our next level of appeal, is the US District Court, which sits kind of a half notch above the bankruptcy court. And the case got assigned to a very smart, very tough district judge in New York named Colleen McMahon. And she wrote a 130-page opinion that is just one of the most compelling things I've ever read. It's basically a close statutory reading of the Section 11, Section 105 question Chris and I were both alluding to. And the question she set out to answer was, look, I know all the policy arguments. I know all the factual arguments. Did they give enough money? I know the sort of emerging test that's emerged in terms of when should we do this and how compelling must the circumstances be. She said, but I'm going to answer a much simpler question. Does the statute permit this? And her conclusion, 130 pages later, was no. And I won't take our time today explaining how she got there. It was a very close reading of the statute with all the rules of statutory construction you might expect to see. And I'm not going to say you couldn't argue the other side, because you can. But I mean, this was absolutely compelling, I think really right. And it has already started to reverberate around the country. So you have these circuit courts that have basically issued opinions saying, yeah, it's not great, but you can do it in compelling circumstances. You now have this lower court opinion explaining why that's wrong and actually doing it in a way that harmonizes the appellate court decisions. And you now are going to start to see it percolate through the other lower courts and then come up to the circuit again. So they've expedited review in the Second Circuit Court of Appeals. I suppose it's possible that one or more circuit courts will find a way to refute her. But I can't sufficiently emphasize in the U.S. what a just unbelievable event this was. I mean, it was like a mortar going off. because here's a major component in the Chapter 11 toolbox. I mean, it's just one of the core elements when people negotiate their plan transactions that everybody has assumed is there, and it's now gone. Now, you still, I think you still can have releases in the US. They've got to be supported by consideration. They got to be approved by the court, and they've got to be consensual, meaning you got to find a way for the parties to the plan transaction and the creditors affected by it to opt in or affirmatively accept. But the whole notion that you're going to drag, tens of thousands of creditors along with your deal and strip their claims in the process, I think is now in very serious doubt. And I think it's a great, for me, it's a great reminder that, we all develop our toolbox. And I mean, that's judges as well as lawyers. And we all make a number of assumptions what you can and can't do. And what I'd call a standard operating practice evolves, in terms of, the assumptions, how you do it and when you do it and what you have to show. And then along comes a judge and says, no, you're not reading the statute right. You can't do this. And in addition, there's now a case in Virginia that said, well, the judge in New York is probably right on the statute. And I also don't think there's jurisdiction under the whole Stern versus Marshall line of cases. Bankruptcy judges don't have, even if you can do this under the bankruptcy code, bankruptcy judges don't have the authority as what we call non-Article 3 judges, not full district court judges, to enter these kind of final judgments, stripping away claims. Because really, a release in this way of thinking is an adjudication of the claim at zero. So there's now that whole line of attack. So can't yet predict where this goes. There's certainly going to be a pretty substantial curtailment and rolling back of the non-debtor release tool. We may see more use of class actions and multi-district litigations to try to resolve claims through more established techniques that don't pose these statutory and jurisdictional problems. But it's a pretty significant development in US practice. And interesting in that when we talked about this 1 or 2 meetings ago, I really thought reform was coming and it was going to come from Congress. So the fact that this lower court judge stood up and raised her hand and said no, and then did it in a way so compelling that it started to change the practice in all these other jurisdictions is just a pretty good reminder that all of these principles and concepts we work with are in perpetual motion and remains to be seen where they go. So that is my Purdue Pharma report, and we have a little more time. I was hoping we could just do a quick trip around the horn and see what's going on in all of your jurisdictions. Christian, could I start with you? Anything happening practice-wise in the economy otherwise?
Yeah, of course. I took a look at the case numbers of insolvency cases, and they are still quite low. I checked the data, and they say that compared to October 2019, and before the Corona crisis began, the number of business insolvencies in October 2021 was 33.7% lower. So not much. This is not a big number. The most recent numbers indicate a growth in corporate bankruptcies. If you compare the data, they are now compared to December 2021. They're 18 point higher. So there's some rise in the cases. So let's see how this will develop in the future. And one interesting thing is the Bavarian State Ministry of Justice has made proposals to reform and modernization of German insolvency law. I just pick out three points here. What they're thinking about is to concentrate the insolvency cases with to a less number of insolvency courts. Right now we have quite a large number of insolvency courts and relatively small number of proceedings. They are thinking about to create bigger courts in the larger cities like Munich, Frankfurt, and Berlin, and so the number of insolvency courts actually will be lower. One reason for this is that they got the feeling, and we have that too from a lawyer's perspective, that with such a high number of insolvency courts, it's not possible to have the necessary expertise among the insolvency judges. That's a problem here in Germany. So let's see how this works out, if they really change that. I think it's a good idea. What they also try, what they're also thinking about is to have standard application forms for standard insolvency proceedings. And I think this would be helpful too, because right now we don't have those standard application forms, and this often leads to queries due to insufficient information on part of the filing. And the next step is they want to change the proceedings, the insolvency proceedings, to written proceedings as a rule. The creditors are often located in any place in the country and abroad. And right now, standard proceeding is we have a conduct in verbal hearings. It's insolvency court, and this really is not up to date because it disadvantages the majority of creditors compared to the few local creditors that might be there, and it's quite random if there are a few local creditors. So they're thinking about changing that. And one thing they are thinking about to amend is that there will be a preclusive time limit for the filing of claims in the insolvency proceedings. Right now, in Germany, if you can file a claim, an insolvency claim, until the proceedings are about to end, then there's a time limit, and then you're excluded. But if for example, if the proceedings carries on for 3 or 6 years or whatever, you can you're not time barred in any way to lodge a claim. So they're thinking about putting into German insolvency law a preclusive time limit. So for us, from our German perspective, this would be quite a significant change. And yeah, so let's see how this plays out.
Thank you very much. It's all interesting to hear. Sue in London, could I come to you?
Yeah, sure. Yeah, I mean, it's an interesting market over here, because I think, sort of like many jurisdictions, it's been quieter than everybody was expecting. But you know, the things are shaping up for an uptick in activity finally, and that's generally the market chat across the board, is that there are more inquiries, there's more going on. There seems to be a bit of a perfect storm of macro conditions that are contributing to that, such as the tailing off of all of the government reliefs, the increase in interest rates, inflation going up, sky high energy costs, supply chain and labour challenges. So it feels like there's a lot more activity. We've already seen a lot of the energy companies encountering difficulties. I think there's going to continue to be, you know, difficulties in that sector. Retail, there's still more to come. I think casual dining, there's more to come. There's a whole host of things, certain health businesses, care homes and the like. In terms of sort of legal changes, there's not a great deal going on. We had our legal changes really at the outset of COVID. There's some new change. There's some new laws coming in about how to deal with the arrears of rent that built up over lockdown and COVID, but that's about it. And that's sort of got quite a lot of detail to be fleshed out on that yet. So all in all, we do expect an uptick. And can I just mention, I was really interested, thank you very much for the presentation on the Purdue Pharma case. I'm litigating something about a release matter at the moment, very similar to that. And actually, you know, some of the decisions over here where they've looked at releases and decided that they are acceptable. You know, you do hear submissions being made to the court about what happens in Chapter 11s. So it'll be interesting to see, you know, to what extent that's sort of got a knock-on effect over here as well.
Sorry, muted myself. Thanks for that, and all interesting to hear. And I think you are going to get a decision out of the U.S. Court of Appeals in the Second Circuit, probably in the next 3 to 4 months. It will not be the final word, but it will be an important word. So, and I certainly think you're right. In multiple sectors, these companies have not gotten, in most instances, stronger or better over the past year and a half. And Chris, I didn't get to mention when you were talking about the cannabis companies, but when you were describing the flood of capital and, you know, the actual revenue not matching the expectations. We have that story in the U.S. going on right now with Peloton, which is sort of the classic pandemic baby. And I mean, it's just an enormous company. I got to believe they're going to survive, but you know, I just think the expectations were so grandiose, they may need to recalibrate.
They better survive, because like I only got my bike 3 months ago, so I'm paying my $60 a month. I'm afraid that 60 is going to go to $100 a month though.
Well, what you're going to find is you get attached to these instructors. So when they mention the cuts, like, just please, you know, not Alex, anybody but Alex.
Alex Toussaint, he's my guy too. Love that.
Anybody but Alex. He's got to be last man standing. Gregory, could we hear from you?
Yes, for sure. Thank you for the explanation in other countries. I will be quite short because the situation is the same in Belgium as other countries and as in Germany. The numbers of insolvency proceedings are rather low. I do not have all the numbers, but it's about maybe 30–40% less than before the Corona crisis. It is difficult to understand why, probably due to the measures implemented by the state aid, probably. So we'll see in the coming month if the situation will evolve. We'll see. And regarding legislation, we are still waiting for the transposition into Belgium law of the Restructuring Directive, which is an EU directive with important aspects in order to restructure some business here in Belgium. It was normally previously attended for the first semester 2022, but we don't know. Probably there is no draft bill for the time being, so we will see in the coming month if the Belgian legislator will transpose the directive. We are already too late, I think. So I do not know the situation in other EU member states regarding the transposition, but it will be interesting when it will be transposed. I will revert to you in order to explain what are the main changes in our jurisdiction. Thank you.
Okay, thanks so much. Trolls, could we come to you?
Yes, should that be okay?
Yeah,
can you hear me?
Good. Yeah,
I'm sitting at home and my camera went down, so I'm sorry about that. But
no worries.
I do it better next time. No, I think the market is, as Sue explained, moving towards a better place, dealing with the issues that we deal with as lawyers or practitioners. The economy in Denmark is very well and very strong. We had the lowest number of insolvencies last year, and it continued into this year. But I think it's basically driven by the fact that the economy is doing well, and the fact that liquidity, the amount of liquidity in the market is enormous. That will change eventually within a short time, because people have to repay, or the businesses have to repay COVID loans to the Danish state. So we expect the number of insolvencies to rise, but probably slowly, because of the financial issues that we really, as a country, don't have. So on the legal side, we have the same issues as Belgium. We are not a part of the EU regulations in general on insolvency, but we are of course bound by the directive, and we are working on implementing that as is. That will create some changes regarding restructuring, basically, and pre-packs. But I think that's it's will be pretty much business as usual. Then I will say that the cases and issues that you, Jonathan and Chris, talked about, I think it's very interesting. Both it will be hard for us to transfer the debt, so I would be eager to hear more about that at a certain time, but that's due to local regulations, but also the Purdue decision. If when you have the next level decision, if that could be sent around, that could be perfect, or even the one that's already there, the latest one.
Yeah, be delighted to.
We have a medical section as well, but we don't have parties really involved in the OPID issues besides Tiva, so they have some issues on that.
Yeah, a quick question for Hannah. Can I that 130-page opinion? Can I put a PDF of that on the email chain to the group? Will that work? Can I upload?
You can, but what I was actually thinking is, if you sent it to me, I can upload it to our website as a public document, and then we can share the link, so that way you're not sending a 100 and whatever page PDF. But I was also thinking we could do a short recap and include it as a link in there.
Yeah, I'd be glad to do that.
Okay.
I mean, it's we're all busy. I'm not strongly suggesting you read all 130 pages, but it's pretty amazing. I mean, really one of the most influential opinions I've read. So anyway, trolls, I'm sorry I cut in. Any further thoughts?
No. I'm not. No, I'm happy to be able to participate, and I look forward to the future meetings we have. Yeah, that's it. Basically.
Great, very glad you're here. I know we're almost at time, but Satwinder, any final thoughts or remarks on your end?
I think, Jonathan, it's from the, I think the very good exposition which Chris and Gregory, Christian, and you have already given. I think the topic which you addressed, which we had earlier also discussed about that issue on this, and I have nothing much further to add on this, but it was really interesting to be part of this discussion this time.
Great.
Yeah.
Well, thank you everybody for joining. Hannah, anything else on your end?
Nothing other than we are launching a new website. Essentially, it's going to look basically the same, but we'll have a bunch of new features on it, including a lawyer directory. Right now, our directory is sketchy at best, but we are launching a new directory that will make it easier for you to go in and find lawyers and jurisdictions based on their practice areas. That's one new feature. The other will be discussion boards, which I think will be good for us to be able to communicate with these updates, sharing these decision documents, that sort of thing. where you'll be able to start a discussion thread and people can opt in or out of that particular thread without opting out of the group. So if you did have an update on a case that you wanted to share rather than waiting for a meeting, you can use the discussion boards to do so. So we're really excited about that. Should be coming in the next couple of weeks. We've been testing the new site over the last couple of weeks in hopes that we can launch it in February.
That's great. Well, thanks everybody. And Chris, really appreciate your presentation. So thanks for putting that together.
Likewise.
Good.
Thank you.
Thank you.
Good day, everybody. See you soon.